Galen Vaa versus the state of Minnesota.
Please take a moment and get organized and ready to begin. And we know the request for additional time, of course, was denied, so we are limiting the parties to the standard periods of argument that we have in this court, 15 per side. Will there be a division of time with respect to respondents and attorneys?
No, Your Honor.
Okay. And then, of course, appellant has 5 minutes of rebuttal if you choose to use it. So please note your appearance as you begin your argument. Judge Vaa will hear from you first.
All right. May it please the court, Ms. Iverson and Ms. Fondness. My name is Galen Vaa. I am the pro se appellant in this case. This appeal comes from the order and judgment of the district court dated March 15, 2017, which granted all 6 claims for relief for dismissal pursuant to the defendant's motion to dismiss under Rule 12B. All 6 claims were also dismissed pursuant to the judge's order dismissing my motion for summary judgment. I filed a motion, cross motion for summary judgment. I think it best will explain the issues that I have, because they're very limited, by telling you first what issues are not in this case, at least for your purposes. I spent 36 pages drafting a summary of the legislative law relating to retirement of judges in my appellant's brief. I did that with the assumption that this court would have no authority to reverse the district court decision to dismiss claims 1 and 2, because the State Court deliberated over those 2 claims and adjudicated those claims, and I'm not asking this court to reverse the Supreme Court. I did that solely for the purpose of making sure that whatever happens in the Court of Appeals, I intend to file a petition for review under 117 to the Supreme Court, and the only way of keeping those 2 claims alive was by doing what I did. The second legal issue that is not being raised in this case is I'm not claiming that the compulsory removal claim of Judge Satry under Article 8, impeachment in office for corruption by high crimes and misdemeanor, corruption in office, or removal under Article 6, Section 9. Compulsory removal or retirement for disability, for incompetence in office, and for conduct prejudicial to the administration of justice. The third claim I'm not presenting is the breach of contract claim that Satry claimed. The fourth claim that I'm not claiming is the Article 6, Section 5 claim of Judge Satry, in which he claimed that his salary was diminished during his term of office if he had to be retired in the middle of term. The fifth claim I'm not making, or the sixth claim, is that I'm waiving appellate review of the equal protection and due process claims. Finally, the last claim I am not making before this court is the argument that mandatory retirement is either good or bad from a public policy standpoint or for the judiciary. I make no claim that the MDJA or the Judicial Council either supports or doesn't support my claim. And I think the issue of what will the legislature think or how will the governor respond if this court grants and reverses the district court is totally political in nature and has no purpose in this file. Or this court is bound by the law regardless of the political purposes or result. So what am I claiming? I am claiming issue number 1. Did the district court commit reversible error in its dismissal of appellant's fourth claim for relief, Article 6, Section 7, the 6-year term limit, by making the following statement? This claim was raised and rejected by the Supreme Court in Satry. While there is no significant analysis of the issue in the court's opinion, that the court identified the issue and rejected it is enough to invoke the doctrine of stare decisis. For 4 reasons, I believe that legal statement is wrong and must be reversed. First, he cited no legal authority for that statement. There is none. The rule of stare decisis only applies when the record shows in the prior decision that the Supreme Court Justice deliberated with care and investigated all phases of the legal issue in mind And it also only applies when the judicial mind has been applied to and passed upon the precise question. That is the precedent that this court must follow. That is the precedent that the district court did not follow.
Was the issue of Article 6, Section 7 raised in the Satry case?
It was raised by Judge Satry. It was not discussed. It was not decided by Satry, and I will get to that, Judge. Second, the record in the Satry case establishes beyond any doubt that the district court, William Fleming, granted the motion of dismissal by the state on December 23, 1986, and he made no statement of Article 6, Section 7 in his memorandum opinion. Judge Satry then appealed. He filed a statement of the case and petition for accelerated review. Neither of those statements made any comment on his Article 6, Section 7 claim. There was no appellate briefs because of the time limits. So the only written documents that were filed contain no statement at all concerning Satry's Article 7, Section 6 claim. So,
Well, Judge Vaa, let me ask you, wouldn't, if we adopt your position on Article 7, Section 6 regarding the elective franchise, or Article 6, Section 7 regarding term of office, wouldn't by doing so, wouldn't we be rendering the Supreme Court's decision regarding Article 6, Section 9 in Satry meaningless? Because then the statute that says mandatory retirement is the last day of the month that you turn 70 really wouldn't apply under any circumstance unless a judge just happened to fall within that very limited circumstance. So, didn't the Supreme Court really address those in some way? Otherwise, their decision in Satry, it seems to me, it would be meaningless.
Judge, that's not the rule of law. But when you apply the rule of precedent, you don't say, look at the record in the prior case. Are you saying, Judge, that when you're assessing a Supreme Court decision, you look at issues that they don't even adjudicate in determining whether or not they're precedential? I submit that you're wrong on that position.
Well, that wasn't my question. My question was a rather direct one to you. And the question
My
was,
answer is that, yes, if you grant my Article 7, Section 6 claim, you will be saying that the legislature has no authority because it contravenes that section to terminate the tenure of office of a judge.
But the Minnesota Supreme Court has already said that Article 6, Section 9 is constitutional. So
Just in certain areas, Your Honor, just in certain areas.
Well, but if the Supreme Court is pretty clear on that, and very clear in Weiss, without even hearing oral argument and en banc opinion, saying, we want, just to be clear, we just want to make sure everybody knows that Satry is good law, and we're reaffirming that.
In Weiss, Judge Weiss raised the same issue that Judge Satry raised. And the Weiss decision cites the equal protection cases that I am not raising.
Right, but Weiss affirmed Satry.
Certainly, it did.
And Satry, in the Satry case, the Article 6, Section 7 issue was raised, and the Minnesota Supreme Court
Just
flatly denied that by saying that Article 6, Section 9 is constitutional.
By saying that, Judge, you're saying that if one litigant comes before the court and raises certain legal issues against Article 6, Section 9, that every other litigant in the future who raises different legal issues is barred from doing that. That cannot be the law.
No, that's a separate issue, though. This is an issue that was raised in the Satry case.
No, it wasn't. Well, the Article 6, Section 7, it was raised, but it wasn't deliberated over. It wasn't even rejected.
It was the decision of the Supreme Court in Satry covers that one.
It does not. The only thing that it covers is at the end of the case it says, judgment of the district court affirmed. That means that the judgment of the district court dismissing Satry's Article 6, Section 7 claim was in fact dismissed. It's the law of the case. That's the correct way of determining. It's the law of the case. It's not precedential.
But if the Minnesota Supreme Court did not confirm that Article 6, Section 9 was constitutional, how could they have reached that decision without, at least implicitly, determining that Article 6, Section 7 was not in conflict with that?
They forgot about it, is what they did. They either forgot about it or intentionally omitted it and made it the law of the case. If you have a decision of the Supreme Court that does not discuss an issue that a party raises in the opinion, you have the right to file a petition for rehearing under Rule 140. Unfortunately, Judge Satry had no time to do that.
I was gonna say that, did that happen here?
Because the reason it didn't happen is because Judge Walker was sworn in 2 days later. If he would have filed a petition for rehearing, there's no doubt that the Supreme Court would have had to have heard that issue, because the Rule 140 requires the Supreme Court to hear cases where they overlook a major legal issue. That's the legal elephant in the courtroom, Article 6, Section 7. They overlooked it. It's not precedential. It can't be. How can it be precedential if the Supreme Court did not address the issue with deliberation and care? You cannot cite a case for precedent unless the mind of the Supreme Court passed upon the issue. And more importantly, Your Honors, what this court is doing, what the district court is doing, is adding a provision onto Article 6, Section 7 by judicial fiat. What you are doing is saying, you are reading in this provision into Article 6, Section 7. Subject to the authority of the legislature to enact mandatory retirement at a prescribed age, the term of office of all judges shall be 6 years. That's what you are doing if you affirm Judge Oshlam on this issue. You cannot do that. The very first decision of the Supreme Court in the Sibley case in 1858 was very clear. The Supreme Court has no authority to interpolate words into the Constitution which the framers expressly rejected. The framers expressly rejected two propositions in 1955 and 56 when they adopted this amendment. They rejected the constitutional study recommendation that the Constitution read, judges shall retire at the age of 70. They rejected the MSBA's recommendation that recommended judges shall be subject to mandatory and compulsory retirement. How can you read that into the statute with that legislative history? You cannot. And finally, the precise...
Do we even need to get into legislative?
Well, in order for you to determine whether or not Article 7, Section 6, whether or not the people of Minnesota, when they passed that provision, they wrote that provision in 1955, the legislature, when they penned the ballot.
But isn't really the starting point Article 6, Section 9?
Well, the starting point is both of them. You can't throw out one provision and enforce only the other one. If you, all right, why don't we all agree? Article 7, Article 6, Section 9 specifically says, according to the Supreme Court, I don't agree with this, but let's just assume for the purpose of argument, it provides, the legislature may provide by law for retirement of all judges at a prescribed age. Let's just assume that. You can't then say Article 7, Section 6, the term of office provision, which says that the term of office shall be 6 years. How do you reconcile those two? You can't. So what do? You, under the Yetka case that was decided 10 years after Satry, you try to meld them both together and give legal effect to both of them. You try to harmonize them. In other words, you don't throw one out and just enforce the other one. And so by doing so, what you do is you say, yes, Article 6, Section 9 gives authority to the legislature in this area to mandate mandatory retirement, but it is limited by Article 6, Section 7, which states that it shall be, the term of office shall be 6 years. So anyone who's at the mandatory retirement age and is serving out their term, they get to finish their term of office. And by doing that, you harmonize both of them and give effect to both of them. That's the rule of law as set forth by Yetka. I will read to you, I can see I'm not going to get to the second major issue, and I filed a motion. I knew this was going to happen, and I think it's very inappropriate. This is one of the most important legal issues that this court will ever preside over, and I think I should have a little more time.
Well, we have already addressed that, Judge.
I understand that. So, the Yetka case decided 10 years after Satry. These respondents made the same argument that they're making before this court at this time. The MSRS board contends that because Article 6, Section 7 of the Minnesota Constitution specifically gives legislation authority to provide for retirement of judges, the statute alone should control. That was their argument. The Supreme Court, and that's the argument they're making here today. The Supreme Court rejected that. They said, when you compare a statute to the Constitution, especially a constitutional provision that is mandatory, the term of office of all judges shall be 6 years.
But doesn't the Satry decision address that when it says that retirement terminates both the tenure and term of office?
You read it closely, Judge. It says that it terminates the term and tenure of office in relationship to Satry's claim under Article 6, Section 5, diminishing his term of office. Obviously, if I retire, whether voluntarily or involuntarily, my term of office is over. I'm done. I accept benefits. I take the benefits, whether voluntarily or involuntarily. My tenure of office is done. I agree to that, or involuntarily have to do it. That's what they were using. They could have said, Judge, why didn't they say under Article 6, Section 7, Judge Satry's claim is rejected because retirement terminates the term of office and tenure of office of judges. Instead, they said, with regard to the latter claim, and they were referring to Judge's Article 6, Section 5 claim. You have to read the Satry case very closely, and the district court neglected to do that. Finally, the issue that I'm raising could not have been issued in Satry. It's the Satry decision that creates this issue. The Satry language, they decided, for right or wrong, that retirement, that the legislature has authority to enact laws that go beyond providing retirement benefits. Fine and dandy. They said a reasonable component of that is mandatory retirement. Great. Then that raises this issue. Is a statute passed pursuant to the permissive authority of one constitutional provision invalid to the extent that it conflicts with a mandatory provision of another constitutional provision that covers the same subject matter? The answer has to be no. If it's yes, if you say it's yes, like the district court said, why have a constitution? Why do we have Article 6, Section 7, if a statute passed pursuant to permissive authority of under Article 6, Section 9 controls? It doesn't, and yet it tells you that, and yet is precedent that you have to follow for that proposition.
Judge Vaa, you are out of time, so
all right, so the record will show that I was not given the opportunity to argue the second claim for relief.
but we have the benefit of your brief for that.
Right, well, will I be allowed to argue that in my 5-minute rebuttal?
Certainly.
All right, thank you.
Choose to use that as you wish.
I will have to.
Counsel for respondent.
May it please the court, your honors, my name is Catherine Iverson Landrum, and I, along with Catherine A. Fodness, represent the respondents in today's case. The state of Minnesota, Governor Mark Dayton, and Aaron Leonard, the executive director for the Minnesota State Retirement System. Your honors, the task before you today in resolving the appellant's appeal is easy. It's easy because all of the constitutional questions that have been presented to you today are long decided.
All of them have been decided?
Absolutely, Your Honor. In Satry versus State, the Minnesota Supreme Court held not only that mandatory judicial retirement is constitutional, but that it is directly authorized by the Constitution itself. Article 6, Section 9 states that the legislature may provide by law for retirement of all judges. And the Minnesota Supreme Court, in 2 unanimous, binding Supreme Court decisions, have held that that broad language provides broad constitutional authority to the legislature to implement a system pertaining to judicial retirement, which includes a mandatory judicial retirement date. Your honors, this is not a case wherein the Minnesota Supreme Court has simply held that mandatory judicial retirement has survived specific claims under specific constitutional arguments. No. What the Minnesota Supreme Court has held is that mandatory judicial retirement is constitutionally authorized.
Where in the Satry decision does the opinion discuss Article 6, Section 7, and Article 7, Section 6?
First of all, Your Honor, at page 540 of the opinion, it is expressly listed that Judge Satry raised a term of office claim, as Your Honor has already indicated.
Let me rephrase it. Where in the opinion does it say that there's no conflict between Article 6, Section 7, or Article 7, Section 6, with Article 6, Section 9?
That's a very good question, Your Honor. And in Satry v. State, it is a brief opinion. And sometimes the Minnesota Supreme Court speaks in volumes by providing a short opinion. And in this case, it was absolutely unnecessary for the court to dive into and address each and every constitutional article and provision that was raised by Judge Satry, as there were numerous, including separation of powers, compensation claims. What the court held was that all of those claims fail and no additional analysis is needed because Article 6, Section 9 is a broad authorization to the legislature to impose a mandatory judicial retirement date.
So what language in Satry can you point to that supports that position that any and all claims raised by Judge Satry were dismissed? Or not only dismissed, but considered and dismissed?
First of all, Your Honor, the court was careful in listing all of the particular articles and provisions that were at issue in that case. The court also cites, I believe it is 7 persuasive authorities from across the country, because it is true that mandatory judicial retirement provisions are more common than not. The vast majority of states have a mandatory judicial retirement provision. And the court, instead of speaking in detail about equal protection, compensation, separation of powers, rather cited a string cite of 7 different cases, 2 of which, by the way, address an elective franchise claim. And the court also said that mandatory judicial retirement terminates both the tenure and, quote, term of office of judges. And Article 6, Section 7 is entitled Term of Office. The court was well aware of the numerous issues that were presented by mandatory judicial retirement, as the briefing indicates, and decided to speak briefly, yes, but decidedly on this issue. And then in Weiss v. State, the court reaffirmed that position. In Page v. Carlson, 2 years later, the court once again held that Article 6, Section 9 is clear and unambiguous in being a broad grant of authority to the legislature. And this court has stated, and the Minnesota Supreme Court rather has stated in State v. Winona, which is an 1875 Minnesota Supreme Court case, that constitutional provisions of equal authority within their own sphere, as far as that subject matter is concerned, is paramount and supreme. Article 6, Section 9 is the only article in the Constitution that speaks to the retirement of judges. It is a specific provision as to retirement that is paramount and supreme. And to the extent that there's a conflict with the elective franchise clause, then Article 6, Section 9 governs. And that's actually exactly what the Yetka case found, that's cited by the appellant in this case. In that case, it was found that Article 6 is the more specific article in comparison to Article 7, which contains the elective franchise clause. And of course, this makes sense, because the elective franchise clause pertains to all constitutionally elected officers. So if there is a conflict, Your Honor, Article 6, Section 9, and its broad grant of authority rules. But there is no conflict, Your Honors. Article 7, Section 6 provides that it provides the basic qualifications necessary to run for elective office, except as otherwise provided in the Constitution. And Article 6, Section 9 is exactly that. So, Your Honors, because Satry v. State is binding, as the appellant has indicated, and because Satry v. State provides not that mandatory judicial retirement has survived constitutional attack, but rather that it is in fact a part of our constitutional fabric, that Article 6, Section 9 authorizes mandatory judicial retirement. And as a result, all of the appellant's claims failed as properly held by the district court. And I see I have additional time. Does the court have additional questions for me? Thank you, Your Honor.
Thank you, Reminder. Judge Vaa, rebuttal?
As stated, I will use my 5 minutes to discuss the second legal issue, the Article 7, Section 6 issue. My opponent misstated the ETCA decision. The ETCA decision did not state that Article 7, Section 6 was in any way affected by its ruling. It wasn't even discussed in that case. That case involved Article 6, Section 7, and another constitutional article, and the statute that I referred to. The Article 7, Section 6 claim, in essence, is premised upon Pavlak and Minneapolis term limits. The standard of review that the district court should have followed is this: as a guarantee of universal eligibility for public office, the standard set forth by Article 7, Section 6 may not be made more restrictive unless expressly authorized by another constitutional provision. In this case, Article 6, Section 9. The question before this court: does Article 6, Section 9 expressly provide, in clear and unmistakable terms, an additional eligibility standard? Does it authorize the legislature to do that? Of course it doesn't. Every single case that the Supreme Court has decided when it has addressed that issue, they have answered in the negative. It's 9 cases. You will have to ignore 9 Supreme Court cases if you rule against me on this issue. For instance, read the Article 4, Section 6 provision in the Pavlak case. The state claimed that Article 4, Section 6, each house shall be the judge of the eligibility of its own members. The legislature passed a law, said that judges or legislators who are guilty of fraudulently becoming elected are shut out for the rest of their life. The Minnesota Supreme Court said they can't do that. You cannot enact eligibility standards that are in addition to that set forth in Article 7, Section 6. In the Minneapolis term limits case, 10 years after the Satry case, the Supreme Court says age is an eligibility standard that the legislature has no authority to enact additional standards. In that case, the constitutional provision is this. It's the city of Minneapolis, a charter city. The question is, does Article 12, Section 3, which says the legislature may provide by law for the creation of certain public local governments and for the qualifications for office of those who hold elective office. The city of Minneapolis desired to have an 8-year term limit for councilmen. The case went up to the Supreme Court on a writ of certiorari from the federal district court. The Minnesota Supreme Court said you can't do that because Article 7, Section 6 requires that eligibility requirement be stated specifically and expressly. How could the Supreme Court in 1996 throw out the statute or the municipal ordinance in that case without even discussing Satry, if Satry impliedly decided the Article 7 section case in the Satry decision? In other words, if Satry is precedential, the Minneapolis term limits case could not be possible. They would have to say, we decided this issue 10 years ago when we decided that the phrase provide by law for retirement of judges gives the legislature the authority, notwithstanding Article 7, Section 6, to enact legislation, age-based legislation, that terminates the term of office and tenure of office of judges. That's the exact issue here. It's the same issue. They didn't discuss it because precisely the Satry decision is not precedential to any Article 7, Section 6 claims because it was never raised in Satry, it was never discussed in Satry, and to suggest, for this court to suggest that it would be inappropriate for this court to grant this claim for relief and because it would somehow reverse Satry is totally inconsistent with the Minneapolis term limits case. You have to follow the precedent, the decisions of the Supreme Court that decide the actual issues that are raised. And the Minneapolis term limits case decided exactly what I am claiming. Age is an eligibility standard that the legislature has no authority to legislate unless it's expressly set forth in the Constitution, in another constitutional provision. And that means that the Article 6, Section 9, in order to pass muster under the Minneapolis term limits case, must say the legislature may provide by law for retirement of judges at a prescribed age, which shall terminate the term of office and tenured office of those judges, or alternatively, the constitutional provision must say judges shall be retired at the age of 70, like every other state constitution. Read the summary of the state constitutions that I have identified, which in fact are all the state constitutions in which there is mandatory retirement in that state, all of them expressly and definitively and without any doubt set forth the precise authority of the legislature, or they more often than not they say judges shall be retired at the age of 70, judges shall be retired at the age of 72, whatever. That was rejected in 1956 by the people of Minnesota, that language. Thank you.
Thank you, Judge Bob. Thank you, Ms. Langer. We appreciate the benefit of the briefs and the arguments today. That is the last matter we have for oral consideration, and so the court's adjourned.
Thank you.
Please rise.